One woman again was woken from a nap on her holiday by a bullet passing through her window, past her head, formed bedding in her bathroom mirror.
A woman was almost hit by a stray bullet, and now the shooter, Jalen Christ, is in court. Prosecutors say he's dangerous and want his bond raised to $75,000. The defense argues it's not fair. The whole hearing is filled with tension.
That's called the case of the people versus Jalen Priester.
Yeah, I was going to Ken Reddish on behalf of Mr. Priester. Can you say your name for the record, please?
Jalen Priester.
Your Honor, today people are moving to raise defendant's bond $75,000 after the that provision, and in the event of defendant's release, require a home confinement tether. We make this request on the basis that defendant is a dangerous individual who poses a threat to the community's physical safety. He fired a 9mm pistol at least 5 times into an occupied apartment building, striking apartments aimlessly. MCR 6.106H allows a court to modify bond if they find that there is an abuse of discretion. The current bond of $35,000 represents an abuse of discretion because it falls outside the probable and reasonable range of outcomes under the factors laid out in MCR 6.106F and MCL 756.6. I laid out the 9 factors under MCR 6.106F in my brief and will leave those to the court's consideration. All of my argument is focused on MCL 756.6. This includes 4 factors. The first of which is the improbability of defendant appearing at future court dates. We don't have much to say on this factor. We would simply note that defendant was arrested for assault and battery in 2018 and attempted to flee uniformed officers at that time. Moving to the second factor, the seriousness of defendant's charges. They are very serious mistakes. There's a maximum penalty of 10 years in prison, and people have calculated sentencing guidelines between 5 to 23 months. The statute that the defendant violated is designed to protect people in their own homes and in common gathering spaces, places we shall be free and safe to be in. The third factor is the protection of the public. He would have grave concerns with protection of the public if bond remained as is. Defendant has a reputation for being in a gang. He sent death threats to a victim via text. He tried to run that same victim off the road with his vehicle. And one of the neighbors, who was a victim of his shooting conduct, was awoken from her bed by a bullet passing through her window, past her head, and then ultimately embedding in her mirror.
The prosecutor comes in strong, listing every reason Jalen is a danger: gang ties, past arrests, even death threats. She paints him as reckless and violent. Remember, bond isn't about guilt, it's about risk. But is $75,000 going too far?
Defendant's conduct has escalated from targeting one individual to threatening an entire apartment building of people in Washtenaw County. He would have serious concerns if bond remained as is. Finally, the defendant has an extensive criminal record and a reputation for being dangerous. His Clemis history shows at least 33 interactions with law enforcement over the years, in which resulted in arrest. He's included using his telephone for harassment, larceny, and CSC forth. He has demonstrated a severe lack of concern for human life and a willingness to fire a deadly weapon, even when there is a deadly risk to bystanders. Defendant is a dangerous individual, and the factors under MCL 756.6 support raising the bond. He fired a weapon at least 5 times into that apartment building at 3 p.m. on Memorial Day, a date and time when people were particularly open to vehicle. He threatened their safety inside their own homes, a place that they should be particularly safe and free from defendants' aimless bullets and violent tendencies. Instead, their holiday was interrupted by bullets piercing their apartments. One woman again was woken from a nap on her holiday by a bullet passing through her window, past her head, formed bedding in her bathroom mirror. Therefore, the people request that the court raise defendant's bond to $75,000 cash surety with no 10% provision and a home confinement tether upon release. Thank you, Your Honor, and that's all.
Thank you. Response.
Thank you, Your Honor. We oppose the motion for bond being increased. We don't believe that there was any abuse of discretion at arraignment stage. and we ask that the bond be continued at what it is currently set at. All of that, what just was mentioned, most of it, except his criminal history, is just allegations. This is what this case is for, is to go into the allegations. And when the magistrate set the bond, he had all the information that we have now. I don't believe anything that was just mentioned is new information to us, or to either side. I don't believe there have been any violations, no calls coming out of the jail to any of the complaining witnesses. We believe that the bond that it's currently set at is serving its purpose. He hasn't posted bond. He hasn't been able to, so we don't see a reason in increasing the bond, because as it is set out, it is currently serving the purpose of the bond. And there is no indication that he can post what it's currently at. So we don't believe that there was a abuse of discretion in setting it at $35,000. Additionally, I do believe the bond request form at the time of arraignment had the requested bond of $50,000. I am actually unsure what the amount that was actually requested on the record was, but the bond form did have $50,000. I don't know why it would be increased to $75,000 now when there's no new information. Of course, the police report has, its own allegations, such as the threats, but, the police report does not actually include any photographs or proofs of these text messages. But aside from that, Your Honor, we believe that there was no abuse of discretion, and that we oppose that motion. Thank you.
The defense fires back, saying nothing new has come up since the bond was first set. Smart move. They're reminding the court, no new facts mean no reason to raise the bond. It's a bold argument, but will the judge agree?
Your Honor, I believe that the low value of $35,000 simply doesn't match the egregiousness of conduct. $75K is far more appropriate. The police also gathered ballistics and multiple victim eyewitness reports at the scene. I believe that we've laid out a strong argument here for if you raise $75K, that would be the court's discretion.
Did the people originally request 50,000?
I believe so, sir, but we wanted to make sure the bond reflects the egregiousness of this conduct. And
What, and so in the bond motion, that did not reflect it, or what?
I can't go before the prosecutor, but I believe that.
Well, you need to speak for that because it's your same office. So I'm saying you have a 50,000, don't you believe the defendant's point is a good point, that originally you asked for 50,000, that there's nothing that has changed between that point in time and now that would justify a $75,000 bond?
I understand your point, Your Honor, and I think the defense brings up a valid point. If you believe that 50K is appropriate, you can see.
Do you believe that it was an abuse of discretion for the magistrate to set the bond at the $35,000? I will, however, grant the people's motion to raise the bond. Defendant's bond will be modified to $50,000. Cash surety note 10% with a tether if he does post a bond.
Just to clarify, that's a home confinement tether, Your Honor.
That would be a home confinement tether.
Yeah.
With 50,000.
Decision time. The judge raises the bond to $50,000, not the $75,000 prosecutors wanted, but still a clear warning. It's the justice system finding middle ground. Protect the public, but stay fair. This moment says it all.
Not
Cash.
Your Honor. Oh, sorry. I was going to actually address the case. But
Go ahead. No, go ahead.
We're just gonna set it.
I can do more than one thing at a time.
I don't want to make you to have to do that.
Why? I multitask all the time.
All right, we'll be setting for.
Okay, you have my full attention. Boy. Go ahead.
Your Honor, we're gonna be requesting to set this for preliminary examination, please.
All right. You're going to be setting it for a preliminary examination. All discovery is complete.
Yes, Your Honor, I believe so.
All right. The people have their witnesses available. The 12.
We'll do our best, Your Honor.
All right. Has the other he has a co-defendant. Has that been set as of yet?
Actually, the police report is quite scarce. I don't even know the defendant's name.
Is there a co-defendant with this?
I believe so.
I thought there was.
That's precinct, Your Honor, from this morning.
Oh,
Yes. And when is that? Did we
I can
set
look
that
it up real
one?
quick.
But I'm saying this is a different precinct. That set precinct is the one that had a code of it.
Not him.
Oh, okay. I was
Okay,
gonna
so-
say.
Okay, gotcha. Okay. So I will set, would you be ready to go on the 12th?
Yes, Your Honor.
All right, I will set preliminary examination, August 12th, 2025, 9 a.m. in person before Judge Freshour. Bond will be set as I've indicated.
Thank you, Your Honor. May I have a motion to relate?
Pardon? Yes, you may.
Regarding this case? Oh, okay. Thank you.
Thank you, Your Honor.
Yeah, we want to talk without you.
I was like, I need to approach to that.
Jalen's bond is now $50,000 with a home tether. Safety wins over sympathy this time. What do you think? Fair call or too harsh? Share your thoughts below, and don't forget to like, share, and subscribe for more real courtroom drama.